exception there which says that you can't go into issues of patentability and novelty and etc. in that kind of an analysis, because that's simply as far as whether the threats are justified or not. But routinely in threats action litigation, the entire patent is opened up by the court simply because there's really no guideline. Benefits of, I know we're running out of time, so I'll keep this short now. So benefits, my suggestions here are threefold. Benefits of clarificatory rulings for related litigation. Convenience of examination of experts from a pre-assigned roster. Let's have a pre-assigned roster of subject matter experts who can assist the court instead of ad hoc experts being appointed by the court, as is routinely done these days. And limiting factual responses to issues that are framed by the review courts themselves, rather than leave it open to litigants to frame the issues that they would wish to agitate. The growing potential for divergent views between the IPAB and the high courts is another source of trouble. Again, those who are familiar with litigating in India will know that Section 8 has been the bane of our lives for a very long time as attorneys. Section 8 is one which says that if any of the inventors were based in India, then you have to file the patent in India first or seek permission from the patent office before you file it overseas. Completely different interpretations as far as Section 8 is concerned have been given. And what ends up happening is that, and you also have to disclose what your, as far as your prosecution history in other countries are concerned, you have to disclose your prosecution history to the Indian Patent Office. And so what's happening in this particular context is that there is no guideline that is governing the way the IPAB or the courts are treating the disclosure of prosecution history. So we had Chemtura Corporation in the Delhi High Court, which was a writ petition where the court said that the prosecution history of all your patents in every country has to be disclosed in full. Whereas what we used to typically do is file a table where we said, the patent is pending in a particular country or granted in a particular country, or, the examination report is issued, etc. So we'd give a sort of table as far as status was concerned. But now we have a situation where courts are saying substantive disclosure of the various stages in different countries. And that's the view that has been taken by the IPAB in Tata Chemicals. And if you sort of read that extract, which I'm really running out of time, so I'm not going to read that out to you. But if you read that, they take a fairly, strict view to say that if you have not complied with this, then the patent is liable to be revoked. And in Hoffman La Roche,
where as a result of a similar revolt, the European Parliament, which previously had been in favor, and a treaty which 22 nations had signed, the European Parliament, by a vote of 458 to 79, rejected the ACTA agreement. That is now being renegotiated as part of something called the Trans-Pacific Partnership, but the underlying values are still there. And the cultural values that are fighting intellectual property protection are throughout the world and challenging a great deal of what we do. We see that in the patent area, and that's one of the things that's happening in software patents. And it's come to us in the patent area through some remarkable cases in the United States Supreme Court. The first of those cases that hits directly on what we're talking about today is the Bilski case, where the United States Supreme Court held Bilski involved the patent basically for a strategy for hedging investment risks. There were directions to buyers and sellers and how to make investments that would hedge the risk of price changes in certain investments. Both the lower court and the Court of Appeals for the Federal Circuit had found that that was not patent-eligible subject matter because it was not within Section 101 of the Act, but the reason they gave is they didn't use the express test of laws of nature or natural phenomena or abstract ideas that are exceptions to patent-eligible subject matter. They used a test called the machine or transformation test, that if there weren't a machine or transformation outside the algorithm involved, that it was not patent-eligible subject matter. Supreme Court of the United States, in a somewhat confusing opinion, it wasn't quite clear, the majority was very narrow on the critical point, and there were about 4 different opinions in the case. But they basically rejected the machine or transformation test as the exclusive test for what was patent-eligible subject matter. and really said, when all is said and done, that the reason that that was not patentable is because it was simply a set of processes that were an abstract idea and was outside patent-eligible subject matter simply for that. Now, when the Supreme Court of the United States decided Bilski and decided patent-eligible subject matter in that precise way, it also sent back to the Federal Circuit another case that was then pending. And the case that was then pending was the Mayo versus Prometheus case. And what happened technically, the way the courts work, is that after the Court of Appeals for the Federal Circuit decided the Mayo case, which we've talked some about and will more, there was a petition to the Supreme Court of the United States for review, petition for certiorari. When the Supreme Court decided Bilski, which was a set of instructions for an investment strategy, it had nothing to do with medicine, for an investment strategy. Mayo versus Prometheus involves a medical diagnosis patent. But the Supreme Court gave its ruling in Bilski, and it then entered what the court technically calls a GVR order. It granted the petition in Mayo. It vacated the decision of the Court of Appeals for the Federal Circuit that had upheld the Mayo patent, and it instructed the Federal Circuit to revisit and to redecide Mayo based on what was decided in Bilski. And so the question is, since Bilski involved, though technically software was not involved, it was widely read as having implication for software patents. So Bilski involved investment strategies in the context that was thought of in software areas, even though technically that wasn't involved. And yet the court said, decide Mayo, decide the medical diagnosis case on the basis of the principles in Bilski. What did the principles in Bilski have to do with Mayo? What was involved in Mayo was essentially a medical diagnostic technique. It involved the administration of a drug, I think it was theropurine, that was an anti-cancer drug that dealt essentially mostly with kidney cancer. And it simply gave instructions to administer the drug, to read out the set of metabolic processes that resulted. And if the measurement was over a certain level, it was dangerous and should be pulled back. And if it was under, it should be increased. But it was medical diagnosis. It was not investment strategy. But the court said, decide Mayo on the basis of Bilski. The Court of Appeals for the Federal Circuit re-argued, reheard, redecided the medical diagnosis case in Mayo and made exactly the same decision it had made before. It said that it was patentable. Didn't back off a bit. The Supreme Court then grants certiorari in Mayo. Mayo comes back up to the Supreme Court. Now, everyone in the world, the whole biotech community, is viewing Mayo through the prism of a medical diagnosis case. And that is a large part of its implications, and we'll talk about. But the language that the U.S. Supreme Court, and this was unanimous, this was unlike the confused opinion of Bilski. This was a unanimous, single opinion of the court written by Justice Breyer that involved all 9 members of the court. That is not an everyday occurrence, and it is certainly not an everyday occurrence in the intellectual property area. And so what did the Supreme Court of the United States say in the Mayo case that is relevant to what we're talking about? It set out what the exception to patent-eligible subject matter was. And in language that is causing everyone who deals with software patents a great deal of angst, the Supreme Court in the medical diagnosis case found non-patent-eligible subject matter because it was an abstract idea and said a law of nature is not patentable, neither is a process reciting a law of nature, unless that process is more than a drafting of an effort designed to monopolize a law of nature. And in all its previous cases, the court had said that algorithms, which set out processes, whether they be business methods or anything else, were the equivalent of laws of nature. So the Supreme Court gets Mayo back because of Bilski, it finds that the Mayo process is non-patentable, and it uses this very, very broad language, which clearly applies outside the medical diagnosis area, but applies to anyone that is attempting to use algorithms in software patents or elsewhere simply to solve problems, and so is directly related to software patents, which in many cases, not being connected to something else that occurs, simply are applications of algorithms. Now, clearly, there are software patents that are not applications of algorithms. If you're driving around San Francisco, for the past few weeks, you would see on the roads of the Bay Area a driverless car that Google is developing, and that probably is the future of transportation. And clearly, the value is in the software and the telecommunications and everything that controls it. That's a different kind of thing. That's directly connected to an operational machine. But so many and so much of software patents are not that at all. They are simply descriptions using computer software of algorithms. And the language in Mayo seems to say, watch out. The next time that comes up to us, there'll be trouble. Now, we've talked about Mayo in the context of the medical device, and that's the medical problems, and that's where it's gotten so much publicity, because another case that we've mentioned before that went back and has come back up is the Myriad Genetics case, for which the Supreme Court has certified a single issue for argument, whether or not when you go to the court can actually designate. They don't just review the case. They designate what the issue is that's being decided. And the issue they asked about in Myriad Genetics, which is being argued in the next few weeks, is DNA patentable? That's basically, they want to know that on the issue. And so everyone's viewing Mayo, as it applies to Myriad, through that prism. But for our purposes, it's far more significant than that. And there have been widespread comments in the software patent literature in the United States of the implications of the Mayo language to software patents. Now, what do the copyright wars that we've talked about and software patent wars have in common? Well, they both illustrate this bringing in of non-IPR cultural and political values into this issue. The software patent wars, of course, we commented on being fought out in the European Union, though the European Parliament, as you know, in 2005 rejected software patents. The European Patent Office still has rarely granted them. And one of the effects of the unitary patent in the European Union, which we'll hear more from the panel, is that since the European Patent Office has granted and does grant software patents, and the unitary patent will be decided by the EPO, it essentially becomes a backdoor method within Europe for validating software patents against what was the previous overwhelming vote of the European Parliament. Why the concern? Same concern, I think, as with software. There's a feeling that the software patents violate some sense of how things should be developed, invented. It's controlling too much. It's giving too much power to people who have the money to get the patents. And that's a big split here between those who are coming into the patent system and challenging so much of what we do, because to put it in its most forceful way, the argument that's made is so much of the intellectual property rights system has become rights for those who have the money to apply for and obtain the technical intellectual rights, and not those who do the inventions themselves. The incentives have been skewed toward the financial investment and away from valuable inventions that may be created by others, and that because of that, the system has begun to have some effects that people don't like. That also is being played out in India right now. The same sense of cultural challenge to intellectual property. The Bayer case involving the cancer drug, I think, started to be argued yesterday in the Chennai IPMB because of the granting of the patent authorities in India of a compulsory license on the Bayer Nexavar cancer drug. That's the same kind of issue of non-IPR rights coming in because of the values in the Indian system of saying that price is a factor, both in whether patents should be granted and in whether there should be compulsory licensing. And so the compulsory license in the Bayer cancer drug reduces the price from about $5,500 a month to $175 a month. That is not a consideration that would be had by any court or any authority in the United States, or I think in most of Europe, about whether the patent should be granted or there should be compulsory license. So what do all of these things have in common? What they have in common is cultural change, generational change in terms of views of downloading. One of the things that caused so much angst about the treaties, about SOPA and Protect IP and ACTA, is that it criminalized unauthorized streaming of downloads from the internet. So that if some individual willfully, and it would not be a difficult standard to meet in this case, did what I think, I have to tell you in terms of the cultural change, every time I've taught an intellectual property class and asked the question, I get the same answer that all the people who teach this at Stanford and Berkeley and elsewhere tell me. You have a group of students, they all know the law, they're studying intellectual property, they ask the question, how many of you have done unauthorized downloading in a significant way? Every single hand goes up. So here, these statutes basically wanted to criminalize what some generations that are coming along regard as normal and acceptable behavior. And so this is what we will be dealing with. What we all will be dealing with in the intellectual property system is dealing with what I call these non-IPR cultural values and generational values and political values that are not traditionally part of what we have dealt with when we're talking about creating and enforcing intellectual property. That's a broad overview because I think the issue over software patents fits into that issue as well. It's going to be fought out in the Supreme Court of the United States. It's going to be fought out in Europe. It's going to be fought out throughout the world. But in this context of people who are not approaching it from the standpoint of intellectual property, but who are approaching it from the standpoint of information should be free, software should be available, and should not be limited to what we traditionally deal with it. We are now going to have able and far more technical discussions of the software patent area, but as a keynote address, I wanted to set that stage because I think that is a vitally important concept to think through as we deal with what we otherwise see as technical legal issues in the IP area. We'll now proceed to our distinguished panel. Thank you very much.